Hi everyone, my name is Victoria Driesman and I'm going to be presenting to you on case 8.5 Klein versus Pyrodean Corporation and case 8.6 Palumbo versus Nikirk. Before going over each of the individual cases, I want to go through a quick overview of what I will be discussing in each case. I'll be looking at the facts, the issue, the rule, a final answer, and the conclusion that determined this final answer in each of the two cases. On to the first case, the facts of the Klein versus Pyrodean case. In 1967, a public display of fireworks was put on by Pyrodean Corporation on July 4 at the Western Washington State Fairgrounds. This public display of fireworks injured Danny and Marion Klein in an accidental explosion when an aerial shell went amiss and exploded near them. As a result, Mr. Klein suffered facial burns, eye injuries, and his clothes even lit on fire. The Klein sued based on strict liability for participating in abnormally dangerous activity. The Kleins claimed that Pyrodean Corporation did not adhere to various state regulations. Although they did purchase a $1 million insurance policy as required by Washington State, they failed on many other state requirements. For example, they failed to properly bury the motor tubes, they failed to give the local government a drawn image of the fireworks setup, and they failed to have proper crowd control monitors. The issue in this case was that the plaintiff and the defendant argued different reasons for why the arterial shell exploded. The plaintiff argued that it was because Pyrodean's employees improperly set up the display, while the defendant argued this was not the case. Instead, the defendant argued that it was because one shell detonated and knocked over another, and that shell then ignited and misfired. However, unfortunately, the evidence in the firework explosion was all destroyed, so it was impossible to prove the cause of the misfire. Originally, the Kleins filed on 2 counts, the first being product liability and the second being strict liability. Strict liability was granted to the plaintiff, but product liability as a summary judgment was denied. Pyrodean then appealed the partial summary judgment to the Court of Appeals, which brings us to where we are today. The Court of Appeals then needed to answer the primary question: did the Pyrodean Corporation take on abnormally dangerous activities by putting on this public display of fireworks? And are pyrotechnicians strictly liable for the damages from public displays of fireworks? In order to answer these questions, we need to take a look at the specific laws that are applicable in this case. In this case, the law applicable is strict liability. Strict liability originates from Fletcher versus Ryerlands. In Fletcher versus Ryerlands, a mine shaft flooded on the plaintiff's land. The plaintiff argued that strict liability occurred, and this was found true because the mine shaft was maintained an inappropriately dangerous distance from the adjoining land, and therefore strict liability became a part of today's laws and became a part of the restatement of torts. In the restatement of torts, strict liability is discussed in section 519 and section 520. Section 519 discusses how strict liability occurs for abnormally dangerous activity, and section 520 of the restatement specifies what abnormally dangerous activity is. So in the case of the Kleins versus Pyrodean, it was found that conducting public firework displays is an abnormally dangerous activity, justifying the imposition of strict liability. So why was this answer concluded? We have to look at section 520 to specify what abnormally dangerous activity is in this case. It was found that 4 of the 6 cases of abnormally dangerous activities were true in this case. The judge ordered that in this case there was an existence of high degree of risk of some harm to the person, land, or chattels of others. B, the likelihood that the harm that results from it will be great. C, the inability to eliminate the risk by the exercise of reasonable care. And D, the extent to which the activity is not a matter of common usage. So looking at the fourth part, whether or not the activity is not a matter of common usage, the court decided that a large-scale public display of fireworks is not common usage. This is not to say that fireworks are not commonly used, but to put on a public display at such a large scale like the Prior Dean Company did, corporation did, is not common. In the third count, the inability to eliminate risk, it was found that it is impossible for a pyrotechnician to fully eliminate the risk of fireworks, and therefore section 3 was found true. Finally, sections A and B were both true because there was great harm that resulted towards declines, and there was a high degree of risk of these fireworks. The parts of section 520 that were found not true for this case are sections E and F. E being inappropriateness of the activity to the place where it is carried on, and F, the extent to which its value to the community is outweighed by its dangerous attributes. In this case, E was declined to be true because there was a body of water in between where the fireworks were set off and where the audience was watching the fireworks, and therefore this body of water made the location appropriate. And in section F, the extent to which the value the community is outweighed by its dangerous attributes, the court decided that annually we have fireworks on July 4th because society deems the celebratory nature of fireworks to be more important than the dangers of the fireworks themselves, and therefore the value to the community of fireworks outweighs the dangerous attributes of fireworks. However, because 4 of the 6 parts of section 520 were found true in this case, the final conclusion was that the defendant can be held strictly liable for the abnormally dangerous activity of a public display of fireworks. So on to the second case, case 8.6, Palumbo versus Nkerk. In this case, we are looking at the appellate division of the Supreme Court, where the plaintiff, a mail carrier, was attacked and bitten while delivering mail to the defendant. So we first must look at the facts of this case. The plaintiff was delivering mail to the defendant's house, and the plaintiff claims to have been viciously attacked by the defendant's dog when opening the mailbox. The plaintiff claimed that they were unable to see or hear the dog's attack. They were unable to see or hear the dog prior to the attack because a bush obstructed the vision of the plaintiff. In the plaintiff's original claim, they were suing based on personal injuries to recover damage, but this original claim was denied, and therefore the plaintiff appealed, which brings us into the issue and rule of this case. So as I stated, the original verdict was that the Supreme Court decided in favor of the defendant and dismissed the complaint, which led to the plaintiff appeal. The plaintiff appealed based on strict liability in tort that the dog owner should have known about the dog's vicious propensities. Vicious propensities being the tendency of an animal to be vicious. In the appellate court, the defendant's prima facie evidence is that the dog had never previously exhibited any signs of aggression. Prima facie being a degree of evidence that is established if no rebuttal evidence is provided in opposition to the prima facie. So what happened in this case? In the end, it was determined that due to the plaintiff's inability to provide evidence that the dog had any history of aggression, the theory of strict liability was rejected and the case was dismissed. So why was this answer concluded? Well, according to the defendant's prima facie, the dog had never previously been aggressive to anyone, had never bitten anyone, and had never exhibited any vicious propensities in past. Therefore, because the plaintiff was unable to provide any substantial evidence against the defendant's claims, the prima facie was established as fact and the defendant won the case. Thank you very much for listening, and I look forward to hearing your questions. Bye-bye.